So as you just heard, this webinar is being recorded and it will be shared to MAPC's YouTube channel in the days to come where you can access it. My name is Jillian Saul. I'm with APA Virginia. Thank you everyone for joining. I think we have a great webinar ahead of us. I'm going to go ahead and just share my screen to cover some housekeeping items before handing it over. So APA Virginia is happy to support MAPC in this webinar series and to have land use law update. I will let the speakers introduce themselves, but we are welcome Jesse Richardson and Jared Anderson of WVU College of Law. As you can see, this webinar is accredited with 1CM 9264603. We really encourage questions and discussion, but please submit your questions using the Q&A box rather than the chat box, just to allow the presenters to keep track of all inquiries. You can also use the raise hand feature to request to be unmuted to ask your question live during the Q&A at the end of the presentation. Otherwise, if you have any questions, please feel free to direct message me in the chat box with any logistical matters. We will be sharing the contacts of the speakers afterwards in a follow-up email if you are not able to ask your question this afternoon. But with that, I will go ahead and hand it over. Thank you everyone for joining. Jesse, I believe you're muted. There you go.
Thank you everybody for joining us this afternoon. We are going to go through some land use law updates today, and we're going to be moving pretty quickly. So fasten your seatbelt, put your trays in the upright and locked position. We're going to try to not get into the weeds in any of these, but instead try to highlight what planners should know from these. Want to give a shout out to the Mid-Atlantic Planning Collaboration, 6 state APA chapters, the National Capital Area chapter, and 5 other planning groups in the Mid-Atlantic region. We produced a number of webinars over the past several years. This was an effort spurred by the pandemic. We had a 6-part clean water webinar in 2022. And like Jillian said, check out our YouTube page. We have a lot of videos on the YouTube page that you can take for continuing ed. And shout out to the clinic. There's only 1 or 2 clinics like this in the United States on land use. We've got 7 attorneys and 2 AICP planners. We do a lot of comprehensive plans, zoning ordinances, all types of ordinances and land conservation work across the state of West Virginia. We work with land use law students, and we work with law students and private consultants and NGOs. We have a lot of partners that we work with. So here's what we're going to do today. And I'm not going to read each of these because there's a lot. There's usually 1 or 2 cases under each heading, and we're going to try to hit the highlights. So let's do it. Most of you have probably heard of the City of Austin versus Reagan Advertising. The United States Supreme Court decided that case in 2022. And the question in that case was whether the distinction between on-premises signs and off-premises signs was content-based. And some of the circuit courts had come up with a test that said, well, if you have to read the sign to determine whether it is allowed or not, then that means it's content-based. And obviously, that would mean that on-premises, off-premises is content-based, subject to strict scrutiny, and would not be allowed. The court, Justice Sotomayor, writing the majority opinion, rejected that if you have to read the sign test, and said that on premises, off premises is not facially content based. And so the intermediate scrutiny test would apply. And therefore, it wasn't over. The court said Austin now has to show that the ordinance is narrowly tailored to serve a significant governmental interest. But the bottom line for after City of Austin is that you're not going to have to go back and change all your ordinances. Off premises, on premises distinction is allowed. But you still have to have that connection. Wanted to do this Visible Properties LLC case out in North Carolina because I think it really highlights the issue of drafting your ordinances clearly. In this case, Visible wanted to erect a digital billboard, and that request was denied. And the court, the local government said off-premises signs are not allowed, and this was a moving and flashing sign and a message board not allowed. Well, the court looked at this and said, our head hurts. This is really confusing. There's an overlay zone. There are conflicting provisions. This is a mess. But the court went through and finally said, well, it looks like there are conflicting provisions, but we're going to go with the one that allows off-premises signs, and moving and flashing sign and message board are not defined. So we don't even know what they are. They're ambiguous. So they reversed the zoning board and allowed Visible to put up their billboard. So lesson, make sure that your ordinances are clear and don't have internal conflicts. This is another case where in this time it's from the United States Supreme Court, City of Boston. And Boston shot themselves in the foot this time. Boston had a policy to allow private groups to fly flags on the flagpole in the city, on the city office premises, since at least 2005, and they never denied a request. They allowed hundreds of these until 2017. And in 2017, they rejected the request of a Christian group to fly a flag. Here's their mistake. No written policy. So the court said, Boston, you could have made this so that it is governmental speech, but you didn't. And so since you didn't have a written policy, you didn't lay it out clearly, this is a First Amendment violation. You can't discriminate based on religion. And so Boston did not prevail in that case. Be really careful when you allow private groups to fly flags or post signs or whatever. Is that governmental speech, which is you can control that pretty tightly, or is it not, in which case you have to be extremely careful. Now on to religious land use and Institutionalized Persons Act. I love this case. It's an agritourism case. It's a RLUIPA case. You're saying, what? How can it be agritourism and RLUIPA? Well, in this case, in Prince William County, Virginia, the church located in an agricultural district, and they were allowed to do so under a special use permit. But that special use permit had a lot of very elaborate and expensive conditions that they had to complete before they could open their church. And the church looked around and said, you know, farm breweries and farm wineries are allowed in this agricultural district, and they don't seem so different to us. In fact, we can have our own winery and use the wine for communion. And we both have gatherings of people. It looks like the land use impact is very similar. They said these are comparators. Well, the court rejected that, said that farm wineries and farm breweries are not suitable comparators. There was no evidence of any discriminatory intent. The court seemed to place a lot of stock in the fact that the county had said this district is to preserve agriculture. And so therefore, the court gave the local government a lot of latitude. Church is not agriculture. And also they said there's no substantial burden. All they have to do is meet the conditions of their special use permit, and they can have their church. I think, in my opinion, they had a better case than the court led on to. Excuse me, I don't think this is going up to the United States Supreme Court, but a very interesting case. And then the other case for RLUIPA, and this came out the opposite way. And I think in some ways it's like these are similar cases, but this was out of the Eastern District of Michigan, Troy, Michigan. And Adam Community Center bought a former restaurant and banquet hall. And Adam Community Center is a religious organization. That was not a question. And they had 200 members, over 200 members. They were going to hold prayer services there, and they were going to have a library, a gym, a youth recreational facility. The city allows churches to be in this zoning district, but they had special parking requirements and a 50-foot setback from the street and on each side. Those requirements did not apply to the banquet and restaurant facility, and this site did not meet it. A little bit of incriminating language by the director of community development, who said that churches, places of worship, present unique potential negative impacts on the community. But the court said, you know, these similar burdens are not placed on secular facilities, and this seems a lot like the banquet hall as far as land use impact. So the court, in looking at all of this, said there is a prima facie case of unequal treatment, and the city didn't really present any information to offset this claim. And they said it's a substantial burden. There was a lot of delay and expense and uncertainty in relocating. The city had apparently said, well, you can get a variance, had floated that out to Adam, and there was no chance that they were going to get a variance, and the court didn't really like that. And so the court said that the city had no compelling governmental interest to offset the burden imposed on Adam. And now I'm going to turn it over to Jared, who's going to start with some general zoning and land use planning cases, and with Elton John.
Yeah. Jesse, just before I start with the standing cases, there was a question, and I thought that this might be a good time to answer it before we get too far down the road. And the question was, can you clarify what is meant by on and off premise signs?
Okay. Well, and Jared might be a better person to do that than me, I don't know, but my on-premise signs means if I have a restaurant and my sign is advertising that restaurant, it is on premises. So the sign is associated with the use of that property. An off-premise sign is most typically a billboard that is on property A, but it pertains to an activity on property B. And so the sign is on a different parcel of land than the activity that it is linked to. So we also say that an on-premise sign is an accessory use, and an off-premise sign is most likely going to be a primary use or principal use. Is that pretty good, Jared?
Yeah. Yep. So not sure if you see our motif for today, musically inclined, but Elton John starts off my talk. You can go ahead and change the slide, Jesse. And this is a standing case. It's out of Virginia. And it's important to understand that this particular case and the case that follows will only be applicable to Virginia. Other jurisdictions might have similar, but it's important to understand possibly different tests for standing. And so the question is, who can bring a case against a local land use decision? And this case is, I believe, out of Fairfax, Virginia, and it involves a proposed residential treatment center for teenage girls in a residential district. And there were some neighbors that were concerned about that use coming in. And the circuit court said that the neighbors lack standing as an aggrieved people or an aggrieved person. And that's sort of been the status quo of Virginia law since at least 2013, maybe further. But in order to be an aggrieved person, the party had to get this sort of stature of standing. You have to show that there's an immediate pecuniary and substantial interest in the litigation, and that it's not remote or it's an indirect interest. Okay. And so there's a two-pronged test here. The complainant must show that there's a proximity. They either own or occupy land that's in close proximity to the issue in case. And in this case, it's a treatment center. And they need to show that there's going to be particularized harm to them that's not a harm to or imposed to the general public. So you need to have both of those prongs in order to show standing for these kind of issues. The court here said that the complainants or the neighbors had shown that they were in close proximity. So they satisfied the first prong, and they satisfied the second prong in that they said that if they allow this treatment center to go in, then those folks around them would have a diminution of value to their property. And there was at that again, this case is just talking about whether or not the folks have standing. We're not talking about the merits of the case. So at this point, just seeing if they even meet the threshold to have standing to challenge the land use decision. And so the court had to assume at this point that their allegations of property value diminution was true. But if they were given standing and went to court, they would have to prove that, or else it would be kicked kicked out for lack of standing. And so in this case, in May of 2022, and then in the next case, Seymour, we see that the highest court in Virginia had sort of changed how they look at whether or not a neighbor or an entity near a land use decision has standing and is an aggrieved person. And Seymour just sort of follows. It was just a couple weeks later that Seymour followed the case in Fairfax County, and this time we're talking about a shared easement. And so that's how they were, the folks that were complaining about this shared easement. There was a special use permit that was granted. The folks that shared the easement asked for standing, wanted to challenge that decision, and the court again found that in this case, they didn't argue, the neighbors didn't argue a diminution of value. They argued that there would be increased traffic on that shared easement. And so again, they are talking about, do these individuals, these neighbors, get to the threshold of having standing to challenge that land use decision? And that's all they're getting at these two cases. Life for Rent. I actually didn't know that this was the name of a song title, but thank you, Jesse, who has encyclopedic knowledge of songs and artists. We're going out to Illinois for this case, and this is a short-term rental case. And here we have the property owner. They lived in the property in question sometimes, and it sounded like from the record that they had a property out of state that they lived in part of the time. And what they wanted to do is they wanted to, and what they were doing was they were renting out their house and then sort of leaving the property. And the village of Barrington Hills said, you can't do that. And it sounds like it went on for quite some time, to the tune of $27,000 in fines over the course of, I'm imagining months and maybe even years. Pretty amazing. What happened was, and the key to this case, I think, is that there was no definition of short-term rentals. There were no provisions for short-term rentals in the village of Barrington Hills. And so what happened was, in the case, is that the owners argued that this was a home occupation, that it's in our home, we're using our home as a business. And the village sort of said, that city officials were saying it's not a home occupation. And in fact, they sort of looked at it, and then of course the court had sort of agreed with, there are provisions in your codes that talk about home occupations, which were allowed in residential areas, but this is not a home occupation. So let's go to the next slide. And the way that Barrington Hills had sort of promulgated their home occupation provisions was that there needed to be no outside evidence that this business existed, essentially. And so they looked at, and the court agreed with, the fact that the property was on VRBO website, that there was extra parking for folks that were coming in. And they even looked at the fact that there was a padlock on the door. I thought that was a little interesting, that the padlock, I think the padlock in and of itself wouldn't be an indicator necessarily, but I think they sort of looked at everything together and said, this is not a home occupation. This is clearly beyond a home occupation. And I think the real essence of this, and the real takeaway, is that you need to not only have definitions and have provisions for things that are hot topics or that you see coming down the road, but you need to be very clear. Jesse alluded to this in an earlier case. One of the things that we really focus in on with our ordinances and our work with communities is that definitions are important, and being clear and cogent and making sure that what we're saying in the definition is what we're trying to describe. And then the provisions need to reflect that definition as well. Here, Barrington Hills had no definition. And so what you saw in the court case was that they were squabbling over, well, is it a use? Is it a business? They even talked about, is it a lodging hall? Is it a hotel? And so it just went back and forth. And what the court ended up saying was that it's not a home occupation. It's more akin to a business. You can't have businesses in a residential area. Ring my bell. Anybody want to guess what this kind of case is going to be? We'll figure it out. It's a telecom case. I couldn't come up with anything better. Always love having a good telecom case in, because we're talking about federal preemption. I love this case because it sort of shows the nuance of local government planning and land use. Here we have the town owned land, the telecom company or the tower company wanted to put a pole up on that property. Town officials were fine with it, okay? They even had private consultants that had said, yeah, this is great. It substantially complies with the zoning ordinance, and so we have no problem with it. And so, but in Chesterfield's provisions, it required for cell towers to go through a special use permit or a conditional use permit. And so it went to what they have is the Zoning Board of Appeals, and the Zoning Board of Appeals denied the permit. And at the meeting, apparently there was quite a few people, probably neighbors, talking about standing and whatnot, probably neighbors, maybe not, but there are people that came to the public hearing and stated that they didn't want it there. They didn't want the tower there. And so the zoning board denied the permit. Next slide. However, there was a couple things that happened in this case. Remember that with cell towers and 5G and those kind of things, there's federal preemption under the pursuant to the FCC and the Federal Telecommunications Act and a lot of other orders and regulations that limit how local governments can deal with and address cell towers in their communities. And one of the things that's required of local governments, again, coming from the federal level, is that a denial of a permit for a cell tower needs to be supported by substantial evidence. And so there was a denial by the Zoning Board of Appeals. And what the court said was you didn't have substantial evidence for the denial. The court record kind of shows that the Zoning Board of Adjustments, the VZA, they had sort of leaned on the fact that it's a residential area, that there was a lot of people that came to the public hearing, and they were not super supportive of the cell tower. But here the takeaway is you need to, if you're on a board and you're making these decisions, you need to make sure that your decisions are consistent with the provisions that the elected officials have proffered. In this case, the code had said that, and it was very clear that cell towers were to be permitted in residential areas on town-owned land. And so exactly what they denied it for was in code as saying, we encourage this. I don't know the reasons why they were specific on that, but they had it in their code. And so the court looked at that and said, well, that's, the decision by the board is in direct contradiction to the provisions that are outlined in the municipal code. And not only that, there were private consultants that the town had hired that had said sort of the same thing, like it substantially would comply with zoning, so we don't have an issue with it. And so the court was swayed by that fact, and the fact that the record from the public hearing sort of alluded to the fact that most of their determination came from the fact that there was people that were concerned or upset that showed up to the meeting. And while that's part of the land use process, in this particular case, when you're talking about federal preemption, you need to have more than just that. Bridge over troubled water. What in the world could that case be about? Oh, this is a takings case, and this is out of DC. Really interesting. There's an old trolley trestle in DC somewhere. I'd love to find where this place is, because the facts of the case are pretty amazing. And especially if you're familiar with DC, you're gonna kind of question the fact that there's no economically viable use of land in DC. Where are they talking about? But what happened was the local transit authority owns this land. And what I can only guess was the actual bridge itself and the area around the bridge. And they didn't want it anymore. There's long since no trolleys were running across this bridge. It sounded like it was in a state of disrepair, but it did have historical significance. And so the transit authority, I think, was in contact with the National Park Service to try to get it off their rolls. You know, the transit authority didn't want it. Maybe we can give it to the National Park Service. National Park Service said, we're not dealing with it unless you get the bridge off, unless you get the trolley off. So the transit authority wanted to get a demo permit. And the issue then became they needed a permit to demo the trolley bridge, because it's protected under historic preservation laws of DC. And under DC, there's a mayor's agent for historic preservation. The mayor's agent for historic preservation granted the demo permit and stated that the reason that they granted the permit was that if they didn't grant the permit, that it would be a regulatory taking, as the bridge has no economically viable use. And the court sort of stated, oh, wait a second. What you're saying is that there's no economically viable use, then there's a government action, and there's still no economically viable use. And so if you could go to the next slide, Jesse. Oh, actually, I snipped the slide. But what I was going to say was that if there's no economically viable use before the government action, and then there can't be a taking. There can't be a per se taking in this case, because both before and after the government action, there was really no economically viable use. And so there needs to be something akin to the property was worth X amount of dollars, then a government action happened, and now there's no economically viable use in order for someone to argue that there's been a regulatory taking.
So Jared, you have a very good question in the question box for you. I'm glad it's not me. How do you balance the need to be very specific in defining terms in land use ordinances with the rapid change in technology and wanting codes to be broad technology agnostic, meaning not writing a code that will be out of date in a couple of years and then having to rewrite?
Yeah, that's sort of what we're up against as making definitions and sort of in getting that balance, is that you do want to be clear. You do want to be clear, and it is a balance. It is a balance of, can I create a definition that is both clear, understandable, not only to the decision makers, but to the general public, but it's also, gives some wiggle room. I think in some cases, I'm thinking technology from the standpoint of, cell towers and those and 5G is just so rapidly changing. And I know none of us want to go through a cell tower ordinance like all the time and create different things for the different technologies that are happening all the time. But I think it's really a case of what works in our community. If there's a lot of development going on in your community, then you may want to err on the side of being a little bit more open with your definitions. Whereas the communities that they're not seeing a lot of development and there's not a lot of rapid changes, like we're seeing a lot in West Virginia, I think you have a little bit more license to kind of fine tune it and to be very descriptive in your definitions. But it's a great question, and it's something that we struggle with all the time, is do we pigeonhole ourselves too much? Are we leaving out things unintendedly with our definitions? It's just, it's an art form, and it's trial and error, and it's community specific. I wish I could give you a better answer than that, but it's really tough.
And some of the participants were gracious enough to help us with the location of that trolley, Jared. So
Awesome.
Jillian would leave that up on the Q&A so that we can look at that. A couple other questions real quickly, and then we'll move on. Can you clarify, did the National Park Service say that they would take the bridge but without trolley tracks? Or was it land that NPS would take, but the bridge needed to be demoed?
Yeah, that's a good question. My understanding of the based off of the court record was that the National Park Service would take the land, but that the bridge needed to be demoed. That's my understanding.
And another question, could the historic trolley bridge be used as a bike pedestrian bridge? Not sure how the no economically viable use was determined.
Yeah, I think that it was a state of again, going back to the court record, I think there was a state of disrepair, and that the rehab of the bridge was cost prohibitive almost. I could be wrong on that, but I think it was in the order of hundreds and hundreds of thousands of dollars for the rehab of the bridge. So, but yeah, it's a very interesting case.
Well, thank you, Jared. And now I'm going to move to probably the most controversial issue that we've seen in the past year in the land use arena. In 2022, the United States decided the Brewing case. And in that case, Justice Thomas, writing for the majority, changed everything about, well, not everything, but there was a significant change in how we're going to have to look at Second Amendment cases now. Justice Thomas said, when you're looking at the core rights of the Second Amendment, which is basically the right to carry a gun and the right to self-defense, Thomas said, we're not going to mess with strict scrutiny or intermediate scrutiny because this is a core right that's in the Constitution. What we must look at is that the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. He said that individual self-defense is the central component of the Second Amendment right. And therefore, the question is whether the modern regulation on the one hand and the historical regulation on the other hand impose a comparable burden on the right of armed self-defense. And is that burden compared? And whether the burden is comparably justified is the central considerations in this inquiry. And so now, going forward, and we did a webinar on the Second Amendment and land use a few months ago, and we got into the weeds on this. Can't get into the weeds today. But what local governments are going to have to do now is say, we want to regulate guns in a certain way. We need to pull out the history books and see how were guns regulated in colonial times or even before colonial times. What's been the historic tradition? And Justice Kavanaugh stressed in his concurring decision that this doesn't mean that local governments can't regulate guns. You can. And it doesn't mean that you have to find an exact regulation back in 1753. But you're going to have to find analogies. And so it's been really interesting. One thing that I think is somewhat of a saving grace is that historically, legislative assemblies, polling places, and courthouses are among what we call sensitive places. And in these sensitive places, we can prohibit the carrying of firearms. And we can prohibit firearms, period. And if you look back historically, did towns have regulations that you can't discharge firearms in densely populated areas? That sounds pretty reasonable. So the impact in this case, there's been a lot of impacts, but it's been very interesting to see one judge, I believe in Pennsylvania, there's a lot of gun cases in Pennsylvania, but one judge said, I want to appoint a historian to give me advice and do research for me on what the historical rules on guns are, so I can decide these cases. Another judge recently bemoaned the fact that he criticized the attorneys involved, really ripped into them and said, you all have given me lots of cites to law review articles written by lawyers, but I don't see anything written by a historian. You need to give me something that tells me the history. So courts are taking this seriously. They're looking at the history, and that's what land use planners are going to have to do as well. One other case out of Pennsylvania, and I just want to mention it because I think the court did this partially correctly, partially not. There was a gun club that had been there for a long time. They sold the gun club. The local government didn't want it there, obviously, and so they tried to say that certain types of firearms would be prohibited. And the Court of Appeals in this case accurately said, well, first we need to look at the historical foundations. And this distinction, I think it was center rim versus other, this distinction is not historically valid. But then the court made a mistake and went on to say, well, intermediate scrutiny applies anyway. They came to the right result and said that there's not a fit between the rules and the public benefits. But once you find that there's no historical analogy, the analysis ends there under the United States Supreme Court's most recent ruling. So is it a nice day for a white wedding? Apparently not, because one of the most contentious issues out there today is, are wedding barns agritourism? And agritourism itself is a huge issue today because agritourism in a lot of states receives some exemption from zoning, or in some cases exemption from the building code, and also some other benefits. And here I have, I told some people at a webinar that I did that if you want a wedding to be agritourism, the goat has to be the ring bearer. And here we are. We have a goat as a ring bearer. But Ohio probably has the best jurisprudence on this. And they really take an analytical approach to it. Here, Paulette had some weddings in a barn, and he claims the ag exemption from zoning. And he says, I educate people about the farm during these weddings. The guests at the weddings interact with animals, they take hay rides, all of that. But the court said the wedding in and of itself is not an agriculturally related activity. The court really drilled down on it and said, they're using the upper portion of the barn for these weddings, and all of the agricultural activity occurs somewhere else. So the guests are going to have to exit the barn, go somewhere else to learn about agriculture or engage in agricultural activities. So at least in Ohio, you have to have a really, really tight connection between agriculture and the wedding. And whether that be that the food that you serve be grown on the farm, have a goat as the ring bearer, the guests sit on hay bales perhaps, you have animals in the same room as the barn, I don't know. But one thing that we're struggling with here is trying to figure out, when are these agritourism activities really agritourism? In West Virginia, the big thing now is bouncy houses, which I don't see how that's agriculture. I had to mention Paulette again because Paulette filed a malicious prosecution claim against the zoning officer and said that in coming after Paulette with respect to these weddings, the zoning officer was out to get him. And the court said the zoning officer is entitled to immunity, and the zoning officer did not act in bad faith or in a wanton or reckless manner. The court actually said, what we have here is Paulette interprets the zoning ordinance in one way, and the zoning officer interpreted it a different way. That's not malicious prosecution. And in fact, the court agreed with the zoning officer. So we're going to end up with Elton John because Jared and I have both seen Elton John on multiple occasions. And one concert, Jared's young daughter came with us. That was a lot of fun. She loves Elton John. Another big issue today are wind turbines and solar. I have two solar cases for you today. They come to opposite results, and I think it comes back again to the drafting of the ordinances. And, I'm going to add something here. I think it's the drafting of the ordinance and the findings of fact and conclusions of law that the zoning board comes up with. I think that's really important here. This case out of Massachusetts, very rare. The court was very colorful and very scathing in its review of what the zoning board did in that case. The court said that the denial of these special use permits for solar arrays, despite the fact that all of the evidence showed that substantial mitigation steps were taken, is, quote, one of those rarely encountered points where no rational view of the facts the court has found support the conclusion that the applicant failed to meet one or more of the relevant criteria in the statute. In other words, the court said, we've got evidence that shows that the applicant met every criteria that they had to meet. The planning board just didn't like solar arrays or didn't like them in this particular instance, and that's not good enough. And so the court rejected the planning board's denial of the special use permit. In the second case out of Minnesota, opposite result. And I think probably a couple of things going on here. I think their ordinance was very well drafted to clearly show that in this particular zoning district, the purpose was to preserve the agricultural character of the land. And they had really put out good reasons for that. And the court said that helping preserve the agricultural character of the land is connected to public health or safety or general welfare. So the board here was entitled to deny the application for the conditional use permit. I said there were two things. I think the second thing that we're starting to see, there was another case earlier out of Virginia in a RLUIPA case. Agriculture is special. And I think some courts are really giving a lot of deference to local governments wanting to preserve agricultural land. But again, I think both the ordinances have to be drafted well and be very tight and well-defined terms. And I think when the, whatever you call it, the Board of Zoning Appeals or the Planning Board or whatever, you have to be really careful when you lay out your findings of fact and conclusions of law to make sure that you track the ordinance and that you substantiate the decision that you're making. So with that, we've got 8 minutes for questions, and I don't know if there are any questions on the Q&A board or not.
There are, Jesse, and I think this goes back to the Second Amendment case and out of New York. What are the implications of this decision to other core rights, if any?
That's a really good question. Right now, I have not seen any indication that the court is going to apply this in other areas, except perhaps religious rights, because we did see some cases with COVID where churches were prohibited from opening up and other businesses were allowed to open up, and the court had some pretty strong decisions that said basically you can't limit churches more than you limit other areas. So maybe religious rights, but that's the only one that I've seen at this point.
Yeah. Another question for you, Jesse. Can you just explain how a jurisdiction can limit off-site signs?
Yeah, and that, I wish Whitney was here. I think the key to limiting off-site signs is that it not be content-based. And so if you say off-premises signs, you can prohibit all off-premises signs. I think that's okay. As long as there are other avenues for that speech. But if these are for business purposes, you have even more leeway. You can say off-premises signs are limited to 7 square feet or 50 square feet. You can limit the size, you can limit the color, you can limit the appearance, but you can't say that a sign for, it's like you can't, and this is not off premises, on premises, but you can't say that signs in your yard are prohibited except for sale signs. That's clearly a content-based. You have to stick to content neutral, size, color, lighting, how high it is, things like that. So as long as you're content neutral, you're okay, which can be harder than it sounds. Do you have anything to add, Jared?
No, I think that you nailed it in that you can regulate size, you can regulate the materials, you can regulate to some degree. There's other things, the placement of the sign, the height. Those are all things that are permissibly permissible for off-premises signs. But whenever I mean, and I think this is a generalization, whenever you start looking at what's on the sign and sort of regulating that, you run the risk of running into some trouble. And
flags are a good example. I think a lot of local governments would like to allow people to fly the American flag in their front yard, and it can be as big as anybody wants. But then when somebody wants to fly the Nazi flag in their yard, you can't. If you allow a 100 square foot American flag, you have to allow the 100 square foot Nazi flag. You can't distinguish between different types of flags or signs.
Yeah. There's one more question for you, and then I'll tackle a question, but can you identify any solar farm cases, ordinances that encourage the use of brownfields versus large greenfield areas?
There are some state statutes in some states. If you send me an email, it's easy to find my email. I will try to pull them out. I'm not aware of any local ordinances, but I have looked at local ordinances. Local ordinances seem to focus more on co-location than on brownfields, greenfields, but that's a great point.
Yeah. I'll answer this one. If the planning board or board of commissioners doesn't deny a rezoning request because of citizen testimony and protest, how does that hold up if that is the only reason? The use is consistent with the land use plan and the planning staff recommend approval. I would say that if the board, again, it goes back to what Jesse said, you've got to establish that record. You've got to establish the findings of fact and the conclusions of law, both of those things. And so what I would caution if a community was contemplating or a board was contemplating, there's the angry mob out there, or there's a lot of upset people, you have to be able to look at the provisions, the ordinances, the things in place that have been vetted and approved by the governing body, and be able to make your case to approve and deny based on that. That's sort of the dispositive thing. What is written down? Do you have the authority to make this denial? And if you do, you need to be able to articulate why, right? Certainly in telecom cases, there's the federal reason why, but I think in any case, you're going to want to develop that record and to be able to explain. And so I mean, generally speaking, I would say that if the only reason that you're denying a rezoning request is because there's a few people out there and they're upset, I would say, what does the code say? What does the code say? And really, that would definitely raise a lot of red flags to me as an attorney when a board states that's their only reason is that people are upset. Because if it's in contravention of what the code states, you're definitely going down a slippery slope legally.
One of my colleagues and I have had a big argument about this, about citizen input, and I made the silly statement that you don't have, it doesn't matter, and I don't really mean that. And then I corrected myself and said that if a citizen comes in and says, I don't like it, it's ugly, I don't want it close to me, that's irrelevant. If a citizen comes in and says, the strobe lights from the flicker have caused me to have headaches and I can't sleep at night, that's something different. Or it reduces the value of my property. the citizens have to have something relevant and substantial to add to it, not just, I don't like it. We have a lot of great questions and comments on the Q&A panel. I encourage you to look at that. One person said that off-premises signs are generally huge. So one way you can address it is just say the maximum size for all signs is X. And that's not content-based. So that can essentially prohibit billboards. Darren also said that Sussex, Mecklenburg, and Greensville, Virginia all have ordinances that encourage brownfield site development. And there are other great questions and comments there, but we're out of time. Thank you all so much. We really appreciate it. Do you have any final comments, Jared?
I wish we could. I kind of a little disappointed that the APA is only making the law 60 minutes. This is the first time we've done it in 60, and I feel like we could definitely have gone another half an hour. But again, apologies if we didn't get to your question. You can reach out to Jesse or I. We're at the WVU Land Use Law Clinic. Shoot us an email, and we'll try to provide some resources if we have them.
I think we should sue him, Jared, for cutting it down to an hour.
More than happy to facilitate a follow-up webinar. Also, as they mentioned, all attendees, you will be receiving a follow-up email with the presenter's information along with the presentation slide deck and the link to the recording. So there will be opportunities to follow up, but if you have any questions, please feel free to let me know. But thank you all for joining, and thank you very much to Jesse and Jared. It was a really great presentation.
Thank you, guys.